Hi friends, welcome again to the second lecture related to contracts. Uh, Apart from the first one where we discussed about the historical evolution of the Indian Contract Act 1872, today we would like to cover the basic definitions and terminology in this act and what is the classification of types of contract as per this act. And based on this, we'll discuss the other essentials also. So we'll start with section 2 of the Contract Act. Section 2 has all the basic definitions and terminologies which were the part of my previous video lecture which is posted on my channel. So I would like to repeat this to have a better understanding on the concepts. So if we see before understanding the contract, because section 2 it starts with proposal. So it has the definition of proposal, then how a proposal is getting converted to a promise, what is a proposal maker, which is a promiser, promisee, consideration, and difference between reciprocal promises and the agreement. Then what is an agreement and which agreement is called a contract, and different definitions of contract. And after that we'll discuss about a valid contract, voidable contracts, and other types of contracts. So before understanding the contract, we should first go to the section 2A of the Indian Contract Act, which defines what is a proposal. So this definition has 4 parts. It says that a person signifying other person his willingness to do or abstain from doing something to get his assent is called proposal. So if you see what proposal is divided into 4 phrases, which makes it a complete definition. The first thing is the significance of one person to another person, the intent, the wish, the manifestation of interest is the first thing of proposal. And this manifestation is what? It is for willingness or interest to execute a service or to provide any goods or to deliver any goods, to do or even to abstain from doing, not doing. So this is the third part, that to do or to abstain from doing something. And the last and the most important is to get it assent. His assent is important, his confirmation is important, his approval is important, to whom the promise or the proposal is being made. So this is the definition of proposal, and it gives birth to the concept of promise, which is mentioned in section 2B of the same act. Section 2B of Indian Contracts Act says that the promise is what? The proposal which was made in 2A, if it is addressed to a person to get his assent or confirmation, if that other person he assents the proposal which was made in 2A, then it becomes a promise. So we can say a promise which has duly confirmation, assent or approval to whom it is subjected, it becomes a promise. So section C says, because once the proposal and promises are defined in 2A and 2B, so 2C of the act defines that making proposal, the person who makes the proposal is a promiser, and the person who gives his assent or who accepts the proposal is a promisee. So promiser and promisee is defined in 2C. It's very simple to understand that the person who makes a proposal, which is defined in 2A, is a promiser, and the person who accepts that proposal, the proposal which is defined in 2A, that is a promisee. Section 2D speaks about the consideration and the relevance and importance of the consideration, because it is a very important subject, because lawfulness is related with this, that we'll take up in the future chapters. But just for your information as of now, section 2D defines the consideration, which is basically the result or the payment, or it may be anything which is paid or delivered in return of execution of the promise. Section 2E is very important because it defines agreement, and without defining the agreement we cannot define a contract. So section 2E says, with the definition of agreement, that every promise or set of promise, the promise is one which we just defined in 2B, which is related to the assent of the proposal, which is 2A. So don't forget the relation with this all. So 2E says that it defines that an agreement is it says that every promise or set of promise, it can be more than one promise, forming consideration for each other. So if somebody asks you what is an agreement as per Indian Contracts Act, you have to say that section 2E defines the agreement as a promise or set of promise forming consideration for each other. Consideration is very necessary. So now how it's different from reciprocal promises, which is defined in section 2F just after this. Reciprocal promises and agreement, they only differ with only one point, and that point is that reciprocal promises, they include the partial consideration also. Hence, the definition of reciprocal promise says that the promise which form consideration or part of consideration for each other is called a reciprocal promise. Now we'll go to after 2F we'll go to 2G, H and I, which are very important sections because 2G defines what is a void agreement, 2H defines what is a valid agreement, and 2I defines what is a voidable agreements. So we'll now see what is the difference of them when we'll discuss about the type of contract. But before that, we should go what contract is. So instead of going on 2G after 2F, we have to go to 2H because 2G defines void agreement while 2H defines a valid agreement. Section 2H says an agreement which is enforceable by law is a contract. This is a very basic and very standard definition which we all should remember, that what is a contract. In a single line we can say a contract is an agreement enforceable by law, and agreement is defined already in section 2E. So there is a jurist called Pollock. He defined contract as a legally binding agreement, which is equally true because if something is enforceable by law, it has to be legally binding. So if we mix or merge the two definitions, 2H and 2E, to come to a standard definition of contract apart from what is given in the Contract Act, we can say that contract is a promise or set of promise. This portion we took from the definition of agreement. So a contract is a promise or set of promise which the law will enforce. So now we'll go to the types of various types of contracts. So we have just seen the various sections, and they gave us, section 2H gave us the definition of a valid contract. Now what is a valid contract? We have just seen that it is enforceable by law as per section 2H. And we've seen that it should be a legally binding agreement between the parties. Those are the parties of the contract. It should be legally binding on them. And one important thing is also there related to a valid contract, which is specified in section 10 of the Indian Contract Act. That is the essentials of the valid contract. These essentials we'll discuss in the future classes because these needs to be discussed in detail. But as of now, I can say that when anybody asks you that what is a valid contract, you should refer section 2H, that this is the standard definition of contract, that it should be enforceable by law. In the elaboration, you can say that this definition, standard definition, can further be supported that it is a promise or set of promise which the law will enforce. You can refer what Pollock has said, that it is a legally binding agreement. And then you need to specify that what are the essentials of the valid contract, because these essentials in future you will see that these essentials which are mentioned in section 10, they will be the basis of determining the voidable, void and valid contract. So there are 5 parameters, there are 5 essentials which determine the validity of a contract, and these are free consent. Free consent is further defined in section 14 of the agreement of the Indian Contract Act. So the first component is free consent, first essential, which is defined in section 14. Then competency to contract, it is defined in section 11 and 12. Then lawful consideration and lawful object, these two are defined in section 23. And then it should not be void. Voidability considerations or conditions are specified from section 25 to 30, 32, 36 and 56 of the Indian Contract Act. That all we will discuss when we'll go in details of void agreement. But as of now, for determining a valid contract, which is the first type of contract, apart from the standard definitions given in the section 2H, you should say that what are the essentials of a valid contract, which are specified in section 10, and which are free consent, competency to contract, lawful consideration, lawful object, and the agreement should not be void. So now the second type of contract, which is a void contract, it is specified in section 2G of the Act. It says that an agreement which is not enforceable by law is a void agreement. So the definition is just reverse of what is the definition of a valid contract is specified in section 2H. So it says that agreement which is not enforceable by law, it's a void agreement. The void agreement is illegal in nature. It may be illegal in nature. It will not be binding for sure because it's not legally enforceable. The voidability conditions are determined in section 23 to 30 and then 32 to 36 in relation to contingent contract, which we'll see now, and in 56, which is relation to impossible acts. So now the third type of contract is voidable contract. So voidable is neither valid, it's not void. It can be both actually. So section 2I determines the voidability or the voidable contract, what it is. So it says that the contract which is enforceable at the option of one or more party but not on the other party to the contract means the liberty to declare the contract void remains with only one party, not the other. And if that party decides not to make it void, then it becomes a voidable contract. It can still be operated, it can still be executed, but it can still be declared void at any time, the party who has the authority to declare it void. An example of this, we can see that some contracts which are valid in the start, but in the later course of time, they becomes void. Alternatively, if some contract which is void in the start, but with the due course of time, it becomes valid. So these all types of contracts come under the voidable. They will not be declared void as per the law, but one of the party will have the reservations, will have the entitlement to declare it void at any time, but not the other party. Now, the fourth and fifth type of contracts, they are express contract and implied contract. And these contracts are governed with the promise set up in section 9 of the Act. Section 9 of the Contracts Act defines express promise and implied promise. So these two contracts are governed with these express or implied promises only. So express terms, if we say express contract, it has clear conditions which are clearly specified in the contract for both of the parties. These express contract can be of two types. One is oral and other is written. They can be written. Even the oral contract with due evidence is in place. It is also the part of express contract because there you are specifying what you need and what are the terms and conditions agreed. While the implied contracts, they don't express anything explicitly or specifically. They just mention something, or they are just the manifestation or the agreements which imply the person to execute something to achieve the goal of the contract. So these are governed, these two express and implied contracts, they are governed with section 9 of the Indian Contract Act. The sixth classification is bilateral and unilateral. Bilateral, as the name says, there must be two promises, one from the offerer, another from the offeree. And unilateral, there should be only there. It need not the other person to make a promise. The promise from one party is enough to make a unilateral contract. The example of this could be the maintenance of a child from his father. If one person confirms it, child need not to reconfirm or provide his offer to accept the same. So, and the seventh type, which is very important, is a contingent contract. So first of all, we should know where it is defined in the Act. The contingent contract is specified in section 31 to 36 of the Indian Contract Act. And it says that what is a contingent contract? The contingent contract is valid subject to some condition specified in the contract. So we can say the contract which is dependent on a condition to get fulfilled, it becomes a contingent contract. Section 31 further elaborates this stipulation of contingent contract. It says to do or not to do something. The agreement to do or not to do something if some event which is collateral or secondary to the contract does or does not happen. So it makes it conditional as it relates the validity of the contract to the happening of some event. Section 32, it further elaborates this in terms of an uncertain event. Section 32 of the Act says that the contract which is contingent on an uncertain event, it can be still valid. But if that uncertain event, if it becomes impossible, if it does not happen, then such contract will become a void contract. Like if I say somebody that I'll pay you 1,000 riyal or 1,000 rupees if some ship which is going on this date, it comes back on this date. And suppose, because this is an uncertain event, and if suppose that ship never comes back, it sinks. So that event which was uncertain, it becomes impossible. And then such contract will automatically be void. So this was the basis of how a contingent contract can become void. Apart from this, section 36 of the act says that an agreement which is contingent, but it is not contingent on an uncertain event, but it is directly contingent on some impossible event, it becomes void ab initio. Means since start it is void. So collateral contracts, as I said, these are defined from section 31 to 36, but the highlight sections are 31, which says that it is an agreement to do or not to do something if some event collateral to such contract happens or not. 32 talks about the contract which is contingent on an uncertain event, and as it says, it becomes void if that uncertain event it converts to an impossible event. Section 36 says that the contract contingent on some impossible event, it automatically becomes void because impossible event, it cannot be made a basis of some contract. Now what is a quasi contract, which is the last type of contract, which is the eighth type of contract which we just discussed. Quasi contracts are based on coincidence. These are not here the prime will or the prior intention of executing the contract is not there. They are just a contract based on coincidence. But here the consent is important. We cannot say that these quasi contract they don't have any consent. So if something happens by a coincidence but your consent is required and you are supposed to discharge your contractual obligations, then it becomes a quasi contract. It is seen that in some cases of quasi contract there is a presence of coercion also, means there is a presence of force also. Coercion is defined in section 15 of the act that we'll take up later. But as of now, for understanding the quasi contract, you should understand that quasi contract are based on coincidence. There is no prior intention, but consent is necessary, and in some cases of quasi contract, coercion is present. For quasi contract, I'll take a separate lecture, but as of now, you can understand the basics of it, and it is based on the principle of natural justice. There's a Latin maxim who governs the quasi contract, which is nemo dabt loco pletari ex aliena jactura. I'm repeating it. The Latin maxim who governs the quasi contract on the principle of natural justice is nemo dabt loco pletari ex aliena jactura. It means that you will not benefit from the loss of others. So, as I said, the basic features of these quasi contract, the eighth type of contract is there is no offer and acceptance because there is no prior intention, but the agreement exists, the consent exists, and the obligation exists. The basis of quasi contract is again equity, good conscience, and morality because the origin is from natural law. Quasi contracts are defined in section 68 to 72 of the Indian Contracts Act that we'll take up in a separate lecture related to quasi contracts. So today we have seen the basic definitions mentioned in section 2 of the Indian Contract Act, and then further the type of the contract as we specified. The typical 8 type of contracts you should highlight and you should define whenever you have been asked what are the types of contracts. So these are valid contracts, section 2H of the agreement; void agreement, section 2G of the agreement; voidable contract, section 2I of the act, express contract and implied contracts, which are taken from section 9 of the act, which is related to the promises; then bilateral and unilateral agreements; contingent contract, which are specified in section 31 to 36 of the act; then quasi contract, which are specified in section 68 to 72 of the act. So with this I am closing this, and in the next classes we will go to another aspects related to Contract Act. Thank you. I hope you enjoyed the lecture. Thanks.